Hello. Good afternoon, all. Am I audible?
Yes, sir, you are audible. Yes.
Okay. So let's start with our today's session. First of all, I would like to thank Dr. Thote sir, Abhishek Thote sir, for inviting me on this webinar. In this webinar, which is regarding intellectual property rights awareness. Okay. So as we all know, we are celebrating 75 years of our independence. Okay, we have completed 75 years of our independence, and for celebration of that event, we have as a government of India, we have launched one mission, and that mission is named as NIPAM. Okay, so NIPAM stands for National Intellectual Property Awareness Mission. So through this mission, we are awareing students regarding various intellectual property rights that we are having in our country. Okay, so let's start with our today's session. So I am going to share my screen. Please confirm is it visible or not.
Yes, sir. Visible.
Is it visible, sir?
Visible, sir.
Just a minute. Is it visible now?
Yes, yes. Visible, sir.
Okay, so
Yes, sir. Visible.
visible. Just a minute.
How?
So today's session is on IPR. So IPR is a collective term for intellectual property rights. Okay, so basically in Marathi we can call it as a Bauddhik Sampada Adhikar. Okay, so what is the meaning of Bauddhik Sampada that we are going to discuss in today's session? Okay, so basically intellectual property rights are legal rights. Okay, these rights are kind of legal rights, and these rights are resulting from intellectual activity. So whenever you come across any intellectual activity while working in any of the field, it may be industrial field, it may be scientific, literary, artistic, whatever may be the field. But whenever you come across any intellectual activity, then we can protect that intellectual activity in the form of intellectual property rights. Then what is the meaning of intellectual activity? So intellectual activity means like whatever creative ideas you are getting in your mind, when you convert or when you express that ideas in some of the forms, then we can call it as a intellectual activity or a creative activity. So such creative activities can be protected in the form of intellectual property rights. Now basically properties are of two types. Okay, so property first one is a tangible. Tangible means the properties which we can measure, or the properties which we can see by our naked eyes, or the properties which we can touch. Okay, so for example, in that also there are two types. First one is movable one, and second one is immovable one. So movable means the properties which we can move from one place to another place, like you are having bike, car, gadgets. Okay, so these properties are coming under movable heads, whereas immovable means the properties which you cannot move from one place to another place. Likewise, we are having our house, we are having buildings, lands, all these things are immovable properties. So in our day-to-day life, we are more focusing on the tangible assets. If someone asks you what are the properties that you are having, then you are trying to list out like I am having a home, I am having a land, I am having a farm. Okay, so we are more focusing on the tangible assets, but there are another properties which is called as which is intangible in nature and which is called as a intellectual property, which is coming from your brain. Okay, which is coming whatever creative ideas you are getting in your brain when you express those creative ideas with and with the medium or the expression of that creative ideas can be protected in the form of intellectual property rights. Okay, so basically intellectual property is a intangible property. So intangible means the properties which we cannot see by our naked eyes, or the properties which we cannot touch, or the properties which we cannot measure. For example, you are using various smartphones. Okay, in your smartphones you are having various apps, like for example one of the messenger app is, for example, WhatsApp is there. Okay, in WhatsApp you are typing some message, and as soon as you click on send button, that message immediately reflecting on your friend's screen. Okay, so operating system behind that, or the technology behind that, you cannot see by your naked eyes. So such a technologies or such a properties, we can call it as a intangible form of a properties. Okay, so intellectual property is a intangible in nature, but you can create tangible assets also. For example, you are from mechanical background. Okay, so for example, if you have created any instrument, if you have created any apparatus, okay, so you can see that apparatus, or you can measure the dimension of that apparatus, or you can touch that apparatus. That means though it is protected in the form of intellectual property rights, but it is with the help of intellectual property you can create that intangible property into a tangible assets also. Okay, so with the help of intellectual property you can create tangible assets also. Okay, so in that we are going to discuss, in intellectual property we are going to discuss two types. First one is industrial, in which we are going to discuss patents, copyrights, sorry, patents, designs, trademarks, and GIs. Whereas in copyright, we are going to discuss literary work, artistic work, etc. Okay. So, what is the definition of intellectual property? So, intellectual property basically defined as, for example, any creative ideas, whatever creative ideas you are having in your mind. Having idea is not enough. Okay, you have to express that idea. Okay, so whatever idea or whatever information you are having is not enough. You have to express that information, or you have to express that idea. So whenever you express that idea, and if that idea is having certain commercial value, then we can call it as a intellectual property. Okay, so for example, if you are having a house, then what are the rights you are getting with your house? You can sell it out, you can rent it out, you can even lease it, you can even mortgage it. Okay, so similar rights you are getting with the intellectual properties also. So it is an asset, it can be bought, it can be sold, it can be licensed, it can be exchanged like any other form of a property. Now these are the industrial, these are the two categories, in which first one is industrial, in which we are going to discuss patents, trademarks, designs, and geographical indications, whereas copyright covers the literary works, artistic works, cinematography, sound recordings. All these things are covered under copyright. Okay, so these are the 7 intellectual properties which we are going to discuss in our today's session. Out of these 7 intellectual properties, we are going to discuss patents at last, because we are going to discuss patents in quite detail. Okay, so before discussing all the intellectual properties, what is the need of intellectual property rights? Okay, so what is the need? For example, there is lot of nowadays there is lot of wave of startups. Okay, so for example, if you want to launch a product in market, then what is the first step? The first step will be you have to do certain kind of market survey, or you have to do certain kind of market research. Okay, so in that market survey or market research, you are getting certain inputs, like whether this product is necessary or not. If I have launched this product, then who are my customers, or what will be my target audience? Okay, so such kind of inputs you are getting from the market survey. Once you get some certain inputs, and with the help of those inputs, you try to design and dimension. You try to design that product. Okay, you are during research and development phase, you design that products, you finalize the dimensions of that product, and once you finalize these things, you start manufacturing this product, that product. Okay, so during manufacturing, whatever errors you are getting, you solve those all the errors, and you finally manufacture that final product. And before launching that product in market, you have to do certain kinds of advertisements or marketing. Okay, so and then finally you launch that product in market. Okay, so whatever steps I have explained, from market survey to finally launching a product in market, in each and every step you have to invest your time. Okay, you have to invest your money, you have to invest your manpower. Okay, so all these things are invested, and when you finally launch that product in market, after some days, if you come to know that my similar product has launched by one of your competitors, or your product has been copied by someone else, then whatever efforts you have taken or whatever money you have invested, it might go in vain. Okay, so to avoid such thing or to prevent such thing, what is the what you can do is you can protect your product at the initial stage only. That means whenever your product is in research and development phase, at that time only you can file a patent over that, and after filing a patent you can immediately launch the product in market. And still someone tries to copy your product, then you have legal remedies. Okay, you can sue that guy in court. Okay, you can file an infringement suit for that guy. Okay, now also in the era of digitalization, there are very high chances that your creative data might get stolen without your permission. So to avoid such things, you have to protect your intellectual properties at the initial stage only. Okay, now intellectual property is nothing but a combination of brain, resources, and labor. Okay, so why brain? Because whatever creative ideas you are getting, that are coming through your brain. Okay, and to express those ideas, you will be requiring certain resources. Then resources are like uh, internet can be one of the resource, textbook, reference books, even your machineries in your workshop can be your resources. Okay, so whenever you express that creative ideas using certain resources, and labor means to express those ideas you will be requiring certain manpower. Okay, so whenever you combine all these three things, then the output you are getting will be in the form of intellectual property. Now this is just the basics of the intellectual property rights. Now hereafter we are going to discuss each and every intellectual properties in detail. So first one is copyrights. Okay, so whenever you see such a symbol, okay, so these symbols signifies that this work is protected under copyright. So whenever you see such symbol anywhere, you cannot copy that work. Okay, that means this work is protected under Copyright Act. Okay, so copyright is nothing but a legal term describing rights given to the creators. Whoever is the original creator, whoever is the original author, these rights are given to them. Okay, and these rights are given in 6 fields. Likewise, literary is there, artistic is there, musical is there, dramatic, cinematographic, sound recordings. Copyright is given in these 6 fields. Okay, and copyrights are given for certain period of time. Okay, for example, if you are an individual, then copyright is given for your whole life, plus the after your demise your family will enjoy those rights for next 60 years. Whereas if you are an institution or if you are an entity, then it is valid only for 60 years. Okay, copyright does not cover ideas and information themselves. As I already explained, if you have any idea or information with you, unless and until you express that idea, that you cannot get protection over it. Okay, so you have to express your idea. Having idea or information is not enough, you have to express that. For example, if you are having an idea of a song in your mind, so unless and until you write down the lyrics of that song on paper, you cannot get protection over it. Or unless and until you record that song in the form of sound recording, you cannot protect it in the form of copyright. Okay, so having idea is not enough, you have to express that idea. Okay, then next is there are certain rights like rights of performers, rights of broadcasting organization. These rights we are going to discuss in the next slides. Okay, so these are the 6 fields in which copyright is granted. First one is literary, then films, then dramatics, then musical, artistic, and then sound recording. Okay, so we are going to discuss one by one. So there are many faculties, not only students, even faculties are coming to our office and asking us, sir मैंने एक किताब लिखी है, मुझे इस पे पेटेंट करवाना है. Okay, but book cannot be patented because book is a kind of literary work. Okay, so whatever literary works you are creating, you have to, if you want to protect that literary work, you have to protect them in the form of copyright only. Likewise, books, newspapers, question papers, catalogs, dictionaries, lectures if reduced to writing. Then most important is computer softwares. Okay, you are using various apps in your mobile. Okay, if you develop any app, if you develop any software, if you develop any programming, algorithms, codings, all these things you have to protect in the form of copyright only. These are not patentable. Okay, so